Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
Hey, podcast fans. I'm Gina.
And I'm Sam.
And welcome to the Sam the Answer Man podcast, the podcast where you get your legal questions answered. So I have a legal question, Sam.
Okay.
Could you talk about torts?
Wow, that's probably the broadest question you've given me since we started these. It's a very broad field of law. So torts are basically all bases for a claim by one person against another that are not based on contract. So you have a contract with somebody, you're making a claim because they breached the contract, that's a contract case. Any other kind of case that you make against somebody is a tort claim. And sometimes these are based upon statutes, and sometimes these are based upon what we call common law, which is sort of judge decisions that you get to sue for these things.
And so what types of claims are usually fall into the tort category?
Well, one thing that people definitely think of when they think of torts are personal injury claims. So it's usually negligence. So somebody acted negligently, like, for example, driving a car or leaving water on the floor, and that negligence caused an injury. That is a tort. And there's no statute that says you get to sue for that. That is based upon court decisions that have come down through the years that say, you know, we establish liability as long as you can prove these certain things. You can establish liability for negligence. But torts are not just personal injury. Torts are also business disputes. Somebody says another business is defaming them. Somebody says another business is violating their copyrights. Somebody says another business is taking unfair trade actions that are resulting in loss of profits. These are all examples of torts. And there are different ways of proving all of them. But that all falls into that huge rubric of torts.
So what are some of the defenses? Like, you know, if a business owner is getting sued, what kind of defense do they have, or defenses do they have?
So sometimes it depends on the kind of claim, but some of the things that generally apply is, first of all, if the plaintiff or the person bringing the lawsuit is at fault, then you can make a claim based upon that. They used to call it contributory negligence. And if you could prove that the plaintiff's fault was at all contributory to the result, then there would be no liability. By statute, that's since been changed to say what they call it comparative negligence, which is the jury is asked to assign a percentage of fault to the plaintiff. And if that fault is 50% or more, the plaintiff cannot recover. But if it's less than 50%, they can cover, you know, like if the jury says the plaintiff has 30% at fault, the plaintiff can cover the other 70%. We also now have recently, since the 80s, non-party fault or other party fault. So if there's another party to the lawsuit or somebody who's not even a party, a defendant can say that person's at fault for this injury that you're trying to sue me for, and I want the jury to apportion fault to them. So that's a relatively new area of the law, but it's something that defendants can argue, non-party fault. And that really affects, for example, an improper security claim. Like if you're saying, you know, this restaurant I went to didn't have good security, and I went in there and there was somebody robbing the place and they shot me. I want damages. The business owner could say, I want to apportion fault to the person who actually shot you, you know, and that has really reduced the number of these improper security claims, because then the plaintiff is trying to argue that the business that didn't have enough security is more at fault than the person who did the shooting. So it's really affected a lot of claims. You know, another issue is mitigation of damages. So, for example, if you drive an Uber or something, and I do something to you and you can't use your car anymore, then you can sue for, you know, the loss you had from not being able to drive the car. But if by not driving the car, you saved money because you didn't have to buy gas, you didn't have to pay Uber fees. I mean, I don't know what they do, but, you know, if there's something that you didn't have to pay wear and tear on your car during the period of time you couldn't drive it, that's called mitigation of damages. That's taken against the amount of damages you can claim. For example, in a business context, if I do something that results in you losing a big contract. If you're able to get another contract that you didn't have before, but you were able to do it because you lost the first contract, then that amount is taken off as mitigation of damages against your claim. There's also something called failure to mitigate damages, which is you could have done some things to make your damages lower, but you didn't do them. And a big one, is not getting another job in an employment case, or not seeking other contracts if you're in a business case where something resulted in you losing a deal. So generally, people are under obligation when they've been wronged to do what they can to lessen the damage caused by that wrong. And then another big one, that comes up a lot is statute of limitations. There's defined periods of time when you can file certain claims that run from the date of your injury or when you should have known of your injury. And those definitely should be considered if you have out there a case that you're thinking about bringing.
Now, what about these crazy scooter riders who I see all over downtown Denver? I never see one with a helmet on. Do you think that if they fell and got hurt, could they come after the scooter company?
So I think you're thinking about what we used to have and still do in a way, a defense called assumption of the risk.
Yes.
And so there is a defense called assumption of the risk. It used to be possible to completely defeat a claim based upon assumption of the risk. That's no longer true. Now the way that juries in Colorado are instructed is assumption of the risk is just something you consider when you're considering the issue of comparative negligence. So the jury says, negligence can also be assumption of the risk. Consider that too when you're considering comparative negligence. So there's no real defense based upon assumption of the risk anymore. The other thing is, in the case of seatbelts, if you're driving a car and you're not wearing a seatbelt, the courts instruct the jury to not award any damages that were caused by not wearing the seatbelt. But the failure to wear a seatbelt is not a complete defense to the claim.
So who's liable in these tort claims?
Well, I mean, first of all, it's obviously the person who did the thing, the person who, the other driver or the person who defamed your business. But it can also be, there's something called joint liability or conspiracy liability, which is if you can show that there are other people out there who there was a common plan to do the thing. One example that's given is if two people are drag racing, and as a result of drag racing, driver A hits you, but maybe driver A has no insurance or whatever, you can still sue driver B because driver B was involved in a common plan to engage in a race and that resulted in your injury. And this also happens a lot of times in the business context. If you can say that, this other company was involved in the issue of trying to disparage your company, trying to deprive your company of business, you can sue the other company as well. And in those cases, if you can establish that sort of common plan or conspiracy, you can establish what we call joint and several liabilities. So that's a tongue twister, I know, but basically what that means is you can sue both of those people and both of them are completely liable for your fault. So they do not get to come in and say, oh, he's a non-party, I don't have to pay any fault that you attribute to him. If you could prove a common plan or design or a conspiracy, you can get joint and several liability, which means you can collect the entire amount of your damages from either.
Wow. So what can a business owner do to protect themselves in these situations? Let's say I run a scooter company. What can I do to protect myself when people go out and they don't wear the helmets?
Well, I mean, the first thing is to be careful. Don't be negligent. Don't engage in any designs to harm people. They talk about the standard of care of the reasonably prudent person in the industry. So, try to conform with the best practices of whatever industry you're in to make sure that you're looking after safety the way that you would expect it to as a person in that industry. The second is in a lot of examples, like the scooters, they obviously require you to sign a waiver or release agreement, and those are more enforceable than people think they are. And so at least the person who bought the scooter ride will not be able to sue you, although that's not going to protect you from claims by third parties who this scooter rider might have hit. Incorporating is something that small businesses will do to try to to try to limit liability. It's not as effective as people assume sometimes. Incorporation will prevent you from being liable for the actions of your employees or of the business in general. But even though you are incorporated, you can still be personally liable for your individual actions. And that's an important thing people need to know about incorporation. That if you have a delivery company and your driver hits somebody, incorporation will protect you. But if you are the driver, they can still sue you based upon your own negligence, despite the fact that your company is incorporated or an LLC or LLP or whatever like that. Finally, there's obviously insurance, and insurance, can protect you in a lot of ways. Sometimes doesn't provide the protection you think it does. For example, a general liability policy covering a business will not protect you from defects of your work generally. So you might have to get a separate bond or something for that. But it will at least provide some protection against things like, for example, delivery drivers hitting people.
Okay. Well, you're a mediator, Sam. How would you handle this type of dispute where you have, let's say I'm stuck on the scooter thing. I'm scooter owner. Sally went out and hit her head because she hit a pothole or something like that. How would you mediate that dispute?
So tort claims, and that includes both personal injury claims and business dispute claims, are generally just about money. So the parties probably don't have any continuing relationship. They have no need to get them, to sing Kumbaya and get along in the future. It's simply about trying to figure out how much is going to be paid in order for this claim to go away. And so from that perspective, it's a good idea to assist the parties by recognizing what their risks are going forward, to try to get them to look at it in a business-like way. It's like, you don't have to see these people again. You shouldn't be asking for apologies or, for admissions of guilt or something like that. This is about just trying to find a business-like way in order to resolve this in an amount that both parties can be satisfied with. So those are, in a lot of ways, it's helpful that the parties don't have to have any continuing relationship, because you can just concentrate on looking forward and getting rid of the case.
Well, that is really helpful. Is there anything else you'd like to add?
No, I mean, this is a broad subject, and so we're happy to answer questions you may have about something more specific. But there are a lot of things to think about in terms of operating your business.
Well, on top of that, thank you, Sam. That was very helpful. If you have legal questions, like Sam said, just email him at sam@samventola.com. Or you can also check out, if you want a little bit more information, Sam has written a great article on this. It'll be up on our website, ventolalaw.com. If you're looking for a podcast to listen to, we're on Apple Podcast, we're on Stitcher, we're on Alexa. Watch this. Alexa, play Sam the Answer Man podcast. She's so stubborn. Alexa, play Sam the Answer Man podcast.
Playing Sam the Answer Man. Mediation in practice. Be civil. Types of mediation.
There you go. Alexa, stop. So you can find us on Alexa if you want. If you're not there, subscribe to our YouTube channel. You can see our bright shining faces in the videos. And we're on all over social media. Did you know that?
Yes.
We're on Facebook, Instagram, Twitter. We are everywhere. And so check us out. We'd love to hear from you, and let us know. If you have any legal questions, Sam can probably answer them for you. You think so?
I hope so. I'm Sam the Answer Man.
Yeah, you don't kind of get the moniker of Answer Man without, knowing some stuff, right? In any event, have a super day, and thanks for listening and watching.
Thank you.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law. Mediation and legal representation at an expert level.